Justice Minister Ronald Lamola is still weighing options on establishing an inquiry into alleged political interference in the prosecution of Truth and Reconciliation Commission cases. He was responding to questions in Parliament on Wednesday. For more on this conversation, we're now joined by Justice and Constitutional Development Department spokesperson Chrispin Phiri. Chrispin, appreciate your time this evening. Now, in light of Justice Minister Ronald Lamola's indecision on whether to request a commission of inquiry into alleged political interference in TRC-related prosecution cases, what factors is the Minister considering before making the call?
Well, to start off, it's not indecision at all. You would recall that the Ahmed Timol judgment actually directed that the NPA investigate this matter and come up with a possible plan a plan to address whether there was indeed interference in the TRC cases. And that is how then the Advocate Ndumisa Ntsebesa process came into play. And Advocate Ndumisa Ntsebesa is the one then who then concludes that the best way to deal with this is to have a commission of inquiry. So from where we were sitting, we had satisfied what the court had required from us in the Ahmed Timol judgment. We had referred the matter to the NPA, and the NPA opted for a route where they have an inquiry, which was done by or an opinion which was provided by Advocate Ndumisa Ntsebesa. Now, the question of whether it is necessary to, or the question of how we process the recommendation to have a commission of inquiry on this matter is a matter that requires a lot of consideration. One, what would the cost be to address this commission of inquiry, to have it in place? And secondly, do we then stop with the current prosecutions that are underway? Because we do know, as a matter of fact, that there are 137 cases before our courts that have been instituted by this administration's directions to ensure that we have the resources in place to investigate TRC matters in particular. So those are the considerations at play. With the finite resources that we have, how do we direct them to a resolution that really is a lot more impactful? We do strongly believe that nothing stops the NPA from investigating the matters that are before them, the affidavits that they have in front of them that have been provided by various people, and decide to prosecute or not prosecute individuals who are alleged of interfering with the NPA's work. And this is so because the NPA Act itself makes it a criminal act for anyone to interfere with the NPA's work. So we do believe that this ultimately is a decision, not a ministerial decision, but a decision that lies in the ambit of those who have evidence that there was interference, and the prosecuting authority making a decision to prosecute if that is indeed the case, if they believe the evidence is credible.
Now, the Foundation for Human Rights has expressed disappointment over the lack of progress in prosecuting TRC-related cases, particularly due to the passing of perpetrators. I mean, some of these alleged crimes would have occurred between, obviously, 1960 and 1994. And I was just thinking that an individual, 1960 is 64 years ago. So how does the Minister's office respond to these concerns, and what steps is the Ministry taking to address the challenges identified in this instance?
Like I said, we have 137 cases as we speak right now that are before the court. In fact, today in Benoni, my hometown, there was a case of Caiphas Nyoka who was brutally assassinated by apartheid agents. The perpetrator was hauled before the courts today as we speak. Yes, some of these perpetrators are old. In some instances, some of the perpetrators have passed on. But I think it is encouraging that we're actually seeing the judicial system in place, holding people accountable for their own inaccountability. You would recall that through the NPA, or through the TRC Commission, we had a process where people were given amnesty for telling the truth, and some people didn't take that offer up. So it is of paramount importance that these cases are followed through to their logical conclusion. And we must take note that this is currently happening. In fact, we have a conviction in some places. In the case of Wesley Madonsela and KZN, there's a conviction. Someone has been put behind bars. So yes, it is not an ideal situation that we find ourselves in as a country around this matter, but we must also acknowledge that there is progress, tangible progress at that, where we can see people being prosecuted, where we can see cases being brought before our courts, whether it's the Noctulas Melani matter, the Kosas 4, Caiphas Nyoka, the Neil Agate case. Dr. Neil Agate has also been firmly addressed. Dr. Imam Haroon, Now the Craddock 4 has got its own inquest as well that is underway in the Eastern Cape. So there is a process that is in place to at least ensure that this chapter is firmly dealt with through due process and not through a convenient, shady backdoor arrangement.
Well, I mean, you talk about due process and convenient, but it's an incredible inconvenience to the families who are looking for closure for cases dating obviously way back before the Truth and Reconciliation Commission. And just what needs to be done to speed up the process? Because I'd imagine that many individuals, some have passed away before they saw justice.
It's a judicial process. It's not a political process. It's not a political decision. I think what we must be able to acknowledge here is that, yes, the point at which we've gotten the resources for the NPA to enable it to prosecute these matters in the manner that it's doing now, clearly was unacceptable in the past. But this administration, ministry led by Minister Ronald Lamola in this instance, has tackled that issue square on. So you now have specialized prosecutors in various divisions across the country, from Limpopo to KZN, from Cape Town to Nelspruit, dealing with specifically TRC cases. And we must also understand what the opportunity costs are of this. Ideally, you would want these very resources to be prosecuting everyday crimes. We know that we have a crime situation in our country, but we've had to ensure that we have dedicated resources to address these historical cases, which could have been, I had conceded, dealt with many, many years ago. But none of us were there. The decisions that we've taken now are clear. It is clearly illustrating that we are dealing with this problem in a tangible way through due process. And that's why I say it's a judicial process. These are currently before the courts. So the expectation to speed up some of these cases, like I say, 137 matters being investigated, several number of them before the courts, that is good progress. And in fact, the fact that we have convictions in some cases is laudable.
I don't know if it's fair to draw a comparison and suggest that the resources that are being used in trying to deal with the TRC cases could be used to deal with current cases when we take a look at the history of South Africa and the pain that apartheid caused. You know, it's almost invalidating, if you will, that level of pain by drawing that comparison.
No, it's a fact. You have a prosecutor who could be prosecuting everyday crimes. Now he's diverted, or she's diverted, to deal with specifically only these cases. So your human resources, the human capital that is there, is only so much. The financial resources even required to remunerate people with this skill set. Also, the pool from which we draw for those resources is limited. So that's a reality that we have to contend with. That's an everyday contention in government. There's what we call opportunity costs. So for what we do for the other, we have to forego something in return. And that's just the nature of government decisions at times. And sometimes we have to be frank about it and transparent to say that these are the difficulties and sometimes the constraints that government has to deal with.
Now, Chrispin, given the passage of time and the complexities surrounding historical cases, how does the NPA prioritize and navigate the process of gathering evidence and documentation for these TRC-related prosecutions, especially in cases where key witnesses or perpetrators are no longer alive?
Well, that's a question that I think they can address more squarely, because it does involve their own investigative processes and how they go about it. They do have a states of record. They do have a lot of resources in the form of, for example, something like the Missing Persons Task Team, which is able to draw a great deal of analytical information to some extent, and also relying on some witnesses who were there in the past and are able to explain exactly how these crimes were committed. But how this is being addressed, at least from the Ministry of Justice, is that we have given the NPA dedicated resources to address this specific issue. And we think that the skill set that these type of individuals have is unique to this particular problem. So they do have some level of credible capacity to deal with those historical issues as they present themselves. But nonetheless, I think, yeah, there may well be challenges. But like I say, the fact that in some cases that we've been able to secure a conviction, or there has been a conviction, does show you that indeed the capacity is there to resolve the issue once and for all.
So we talk about the NPA being capacitated. You have, as a department, given them resources. Are there timelines or deliverables or expectations from the Justice Department on how quickly some of these cases can be turned around?
Wouldn't that be interference, setting down a specific time frame for when a case should be concluded? The NPA have the ability to conclude the matter. They must do it without any fear or favor. And we're not going to handhold them to say it must be done by next week Friday. That would be interfering with their work.
Chrispin Phiri, Department spokesperson of Justice, appreciate your time. Thank you for speaking to us on the show.